Professor Robert Burgdorf is a professor at the University of the District of Columbia, the David A. Clark School of Law. He directs the Legislation Clinic and teaches disability rights law and constitutional law. The United States Supreme Court has recognized Professor Burgdorf as, quote, the drafter of the original ADA bill introduced in Congress in 1988, close quote. Quite a testimony to your competence being here today.
Thank you. Chairman Andrews, Ranking Member McKeon, members of the committee, it's an honor and it's a solemn responsibility for me to have this opportunity to testify before the committee. I am humbled somewhat by the thought that there are many Mr. McClures in America. Many people who were told by the Congress, were told by the President, were told by many of us who teach about disability rights law that henceforth they would be protected from discrimination. And today they find out, not today literally, in recent years they've found out that isn't true anymore. Many people who were clearly protected by the ADA when it was enacted, in everyone's eyes that spoke at that time, find out when they are told by a court, you may have a disability, but it's not a serious enough disability for you to be protected by the Americans with Disabilities Act. To put it as simply as I can, the courts have made a royal mess of the definition of disability in the ADA. In trying to figure out how to communicate in a simple fashion, and not in my typical law professor fashion, the complex mess that has been made of the Americans with Disabilities Act, I prepared a little chart that I've attached as Appendix B to my testimony, and I've asked that copies be made available if you'd rather just take a look at it rather than flipping through my...
The members do have copies
Okay,
of that.
They have that. On the left column is simply what Congress said, either in statutory language or in multiple expostulations in the congressional committee reports. The right side is where we've gotten to now. And in each of these instances, the courts have basically rewritten the definition of disability. The things that Congress said, the very language of the statute has been interpreted in a way that now means something totally different. Some of those things have to do with just narrow or broad construction. Some of them have to do with mitigating measures. But they have to do with a lot of other things that the court has taken the term substantial limitation to a major life activity and turned it into a crushing burden, an impossible burden for many people with disabilities to meet. Or if they can, they have to do ridiculous things like prove what their sex life is like. Prove things that have nothing to do with the fact that they were denied employment or terminated from employment. I also put together as another appendix, an Appendix A, just a list of cases. There are many of these floating around now. It's an endless task. This list could be hundreds of cases of particular conditions that people had and went to the courts to say, I've been discriminated against, and the court said, you can't prove that you have a serious enough condition to be protected. That's Appendix A. It's all kinds of conditions: muscular dystrophy, multiple sclerosis, breast cancer, amputation, loss of use of an eye, loss of use of an arm. It's just many things that we were all sure were protected. In the remainder of my time, I would like to begin to address, and I'm not sure I can completely do so, Representative McKeon's concerns about unintended consequences. That's the last thing that we want to have happen. The Restoration Act is based in large part upon a report by the National Council on Disability called Writing the ADA. It's on the NCD websites, and copies have been provided to members of Congress. I was lucky enough to get to be the principal author for the Council of that report. And the Council represents, it's the 15 people appointed by President Bush And they really are concerned with what is happening to the Americans with Disabilities Act. And this report goes at great length to describing the problems, but also trying to suggest the solutions. Let me just address a couple things, and if there are questions about other unintended consequences, I'd be happy to take those on. The first is that this represents an expansion. Well, it doesn't represent an expansion if one understands what the third prong of the ADA said and what Congress and the courts to that time had said the third prong, which is regarded as having a disability, means. I quoted in my testimony from language from this committee's report that says very clearly that if a person is discriminated against because of a covered entity's negative attitudes toward the person impairments, they are treated as having a disability and are covered under the third prong. They also, your report and the reports of all the committees that discussed the definition, quoted from the leading precedent at the time, the Supreme Court's decision in the Arline case, that such an impairment might not diminish a person's physical or mental abilities, but could nevertheless substantially limit that person's ability to work as a result of the negative reaction of others to that impairment. People could have minor impairments, they could have no impairment.